Hello, law geeks. Welcome to CredenceLaw Learning. I hope you are all doing great. And in today's video, we are going to discuss about syllabus analysis of contract 2 along with its expected questions unit wise. So speaking of the contract 2, it is about special contracts in which we are going to talk about four special contracts. One is contract of indemnity, contract of guarantee, contract of bailment, and contract of agency. First three units are about the special types of contracts. After special type of contracts, we will be discussing about sales of goods and the Partnership Act. Speaking of the first unit is about chapter 8, wherein it contains sections from 124 to 147. In section 124, it defines the term contract of guarantee. It says contract of guarantee is it's a contract by which one party promises to save the other from the loss which is caused to him by the conduct of the promiser himself or by the conduct of other person. Here, the liability comes into picture only when there is a loss. That is contract of indemnity. Section 125 talks about rights of indemnity holder, where indemnity holder have a right towards all damages and then right to recover the damages, right to recover the costs, right to recover the sums. And apart from contract of indemnity, from the first unit, we'll also be dealing with contract of guarantee. Contract of guarantee is something which is defined under section 126. Contract of guarantee is a guarantee. It's a contract to perform the promise or discharge the liability of third person in case when there is a default. So the liability in the contract of guarantee comes into picture when there is a default. The person who gives the guarantee is called surety, and the person in respect of whose default the guarantee is being given is called principal debtor. The person to whom the guarantee is given is called creditor. So the guarantee can either be written or oral. From the contract of guarantee, two questions are very important. One is rights of the surety and liability, discharge of the liability of the surety. And continuing guarantee is important for the short note. So these are the important questions from the first unit. Rights and duties of indemnity holder, that is section 125. 124 is the definition clause. And then we have a question. The question is kind of a statement. Do you agree that contract of guarantee is a tripartite contract? Here, yes, it is tripartite, where we are going to talk about essentials of the contract of guarantee, which is given under section 126. It's a contract between three parties: surety, principal, debtor, and creditor. And kinds of guarantee is important for the short note. Continuing guarantee is also equally important for the short note. And rights of surety and discharge of liability of the surety. This is from the first unit. Second unit is about the bailment. So the bailment is covered in chapter 9, wherein it contains sections from 148 to 181. And contract of bailment is a contract where there is a delivery of goods by one person to another for some purpose. Upon the contract to fulfill the purpose. Once the purpose is fulfilled, then the good is to be returned back. So purpose, when the purpose is accomplished, the good is returned as per the direction of the person who is delivering. The person who is delivering the good is called bailer, and to whom the good is being delivered is called bailee. Here, one thing which is important, it is easy to understand the concept of bailment. The we delivering clothes to tailor becomes the contract of bailment. We are the bailer. Contract of bailment. There are two parties, bailer and the bailee. So the one who delivers is the bailer. We are the bailer, and tailor is the bailee. We are delivering the cloth to bailer. That is sorry. We as a bailer delivering clothes to bailee. That is tailor for purpose of stitching. Once the stitching is done, the cloth is to be returned back to the bailer. That is example to the contract of bailment. And then rights and duties of the bailer and the bailee is important. Finder of the good is important. Difference, comparison between the pledge and the bailment. And rights and duties of Pavnar and Pavni. Pavnar and Pavni comes into picture when it is the question of pledge. The difference between the bailment and the pledge is that of the purpose. There in the bailment, we deliver the good to fulfill the purpose, but in a pledge, we deliver will deliver the property for the purpose of security. It is when we keep jewelry as a security, that becomes pledge. And these are the certain expected questions from the second unit. Finder of the good, and then rights of the finder of the goods, rights and duties of the bailee, and right of lien of a bailee, then pavna, pavni, and then circumstances in which non-owner can make a valid pledge, and then pledgee, about the pledgee. Speaking of the third unit, third unit is about contract of agency. So the concept of contract of agency is covered in chapter 10, wherein it contains sections from 182 182 to 238. 182 to 238 is chapter 10, contract of agency. In the here, section 182 defines the term agency as agent and principal. It defines the term agent and principal. An agent is a person employed to do any act for another, where he is representing another in dealing with third person. The person for whom such act is done and who is so represented is called principal. And the one who is doing the act is agent. It is also based on a legal maxim, quid facet per allum facet per se. The one who does an act through another is deemed in law to do it himself. Respondent superior, let the respondent, let the principal be liable. That is contract of agency. And your contract of agency, relation between the principal and the agent, rights and duties of the agent, principal, a relation of the principal with the third party, rights and duties of the agent, principal liability, personal liability of the agent, creation of agency, termination of agency. These are the important questions from the contract of agency. Uh, as you can see on the screen, features of the contract of guarantee, agency, ratification, agent, and personal liability, modes of termination. And it is just a quick information about the classes available. If you are in need of proper guidance, qualitative lectures and notes, and regular check on your preparation, and to get live session and also recordings for your convenience, you can contact through the number which is given on the screen, 7019560214. Then comes contract of partnership. Partnership, section 4 of the Partnership Act defines the term partnership. So partnership is where the people come together, where they carry on common purpose. And your no, the question which is important from the contract of partnership, like partnership, rights and duties of partners, and then types of partners. Minor partner is important. How partnership is created, what are the modes of dissolution of partnership? And these are the certain expected questions from the fourth unit. And then coming to the fifth unit is about the sales of goods. Sales of goods is enacted in the year 1930. Here from the sales of goods, rights of unpaid seller, sale by non-owner, caveat emptor, and then guarantee warranty, and right of stoppage in transit. These are the certain important questions from the fifth unit. And if you are in need of any guidance, you can contact to the number given. And if you have any special request for any topic to be discussed, you can contact to our team on the given number. See you all in the next video. All the best.